Please welcome to the stage, Lucas Nelson, Black Hat Review Board member.
Hello. All right, let me get my notes here. Hi, I'm Lucas Nelson, Black Hat Review Board member, and it is my pleasure to get to introduce Jennifer Granick to you all today. To start, Jennifer's had a ridiculously impressive career. She was the Civil Liberties Director at Stanford's Center for Internet Society. She championed privacy and freedom at the ACLU. She's testified in front of Congress, written a must-read book, American Spies, and helped define how constitutional law is interpreted in the digital age. Essentially, if you enjoy your internet freedoms, you owe her a bit of a thanks. I first met Jennifer at an early DEF CON. I could give you the number, but that would date both of us. I was 18, and Jennifer was already a competent, professional adult, the type of person that might be defending one of my friends in court. She just had this legendary aura about her. She was known as the hacker's lawyer, pretty much royalty in our little group. But she wasn't just some legal figurehead. She was there with us late at night with hackers doing pranks and discussing policy and just generally being weird. She is sharp, fearless, and totally embedded in our community. And I feel privileged to be the one to introduce you to her today. So please help me welcome Jennifer Granick to the Black Hat stage.
Thank you. Hi, everybody. Hi, everybody. Okay. Today I'm going to talk about threat modeling and constitutional law. But most importantly, who here has seen The Avengers, the first movie? Okay, good. I've got my people out there. In this movie, Loki, the Asgardian, has stolen the Tesseract, which is this very powerful cube. And he plans to give it to these alien bad guys who are then going to use it and help Loki take over the Earth. So Director Fury assembles the Avengers to arrest Loki, find the Tesseract, and return it to S.H.I.E.L.D. The Avengers think they understand the threat model. Loki's the bad guy, so are the aliens, and S.H.I.E.L.D's the good guy. So they make a plan and they set out. Pretty soon, though, they realize that while Loki is an existential threat, S.H.I.E.L.D. also has plans for the Tesseract and wants to make weapons of mass destruction using its power. And not only that, but the World Security Council's plan in the case of a security breach like this is to nuke Manhattan. So actually, our privacy rights from the Constitution are kind of similar to this problem. We have a threat model, which is basically focused on the idea of criminals. But it is also true at the same time that while law enforcement needs to investigate crime and have information to do so, sometimes the government, S.H.I.E.L.D., is itself part of the threat model. And when you manage data, hold records, whatever it is that you do with private, sensitive information, it's important to remember and consider that your threat model is not just the Lokis, but it's the S.H.I.E.L.Ds of the world as well. The Fourth Amendment is the way that our Constitution has decided to deal with this balance. On the one hand, the ability of government to investigate crime, and on the other hand, the protection of individual liberties. So there's supposed to be this balance that gives government power, but the Fourth Amendment also constrains government power. But times have changed. There's more information available about us than ever before. When we use the internet, it tracks us. We have our conversations, our friend lists, our social media. When we go out in public, there are surveillance cameras, automatic license plate readers, drones, sometimes equipped with facial recognition or gait recognition, just this network of surveillance that in many ways is new. And as artificial intelligence analysis tools come online more and more, it's just going to be a completely categorically different level of surveillance than not only what we were used to 10 years ago, but then the founding fathers would have even imagined at the time that the Fourth Amendment was adopted. So what's happening is that we have this developing threat. Our attack surface has greatly expanded, and the Fourth Amendment is just hanging out there, not really adapting, and falling short. It hasn't expanded security protections for all this new kind of data that has been created. So one of the particular threats is not just the ability to investigate us as individuals more, but also the ability to conduct mass, suspicionless, dragnet, programmatic surveillance. And just, I'm going to try not to use the term mass surveillance because a lot of privacy lawyers consider that to mean spying on everybody. But basically, we're talking about spying on large groups of people, hundreds, thousands, millions. And this is possible now and far easier than it ever was before. So I'm going to tell you about the Fourth Amendment and how it's falling short. And then I'm going to ask you, as people who are experts in securing information, to come into this fight with us and to think about how you can use your expertise, how you can operate within your companies to try to help protect this data from suspicionless surveillance. I'm going to ask you guys to play the role of superhero in this. And at the end of the talk, you can all have an opportunity to just say, like, which Avenger you would like to be. I am obviously the Hulk because my secret is I'm always angry. So I see my angry people out there. Thank you. Here's to my Hulks. OK, so it was 10 years ago today that I actually did the main keynote for Black Hat. And it's just a real honor to be back. I want to just thank everyone for having me. I really love this community. And I also want to say this is like a good time to say that I work at the American Civil Liberties Union, but I'm giving this talk in my thank you for the ACLU fans. I appreciate that. If you're donating, you're keeping me employed, so thank you. And this speech is in my private capacity and represents my personal opinion and not necessarily the positions of my employer. When I was here 10 years ago, what I said was that the internet that I had loved, that I learned to love, was changing. And that one of the problems was that it was becoming more centralized. And that a problem with centralization is that it makes for cheaper, easier, quicker surveillance. And that threat has come true. But what I didn't know or really get 10 years ago was I thought that the Fourth Amendment was going to be a barrier, a protection from massive, suspicionless surveillance. I knew that each individual one of us was going to have just all of this private data revealed, but I didn't know that governments were going to be able to get that data all at once about millions of us. So I was wrong. I had to address my threat model as well. So let me take a moment to explain why privacy is so important, because I think that I get asked this question all the time, basically. Here, we'll get rid of the Hulk for a little bit. I get asked this question all the time. And we usually talk about privacy and kind of assume why it's important. And I think that's right. It's just part of human dignity to have the right to be left alone. And I am reminded of this every day because my teenage daughters tell me, we have the right to be left alone. I thought you were a privacy lawyer, so stop tracking our cell phones and get off our backs. So I do believe that. But the reason why the Fourth Amendment is my favorite amendment is because I really view it as an enabler of other civil liberties. If you are surveilled or spied on, it chills your participation, your effort to fight for other changes that you might like to see. One of the things we all know is that people in power want to stay in power. And if you do something to challenge the status quo, you yourself can be made a target. So let's just take a look at Dr. Martin Luther King Jr. The FBI surveilled, wiretapped him, having plans with other members of the civil rights movement, but also with sounds of him having sex with women other than his wife. And they sent a package of these recordings to Dr. King with a note, basically trying to blackmail him. And the note said that, basically threatened for him to back down. Otherwise, the American public will know you for what you are, an evil, abnormal beast. And the letter even seems to encourage Dr. King to kill himself in order to prevent the disclosure of this embarrassing information. Our personal lives, we should be able to conduct our consensual relationships as we see fit, without that meaning that we can't participate in political life. Let's face it, maybe people understand this just from hanging out here in Las Vegas. People are weirder than we like to admit, and that's okay. We should be free to think, say, and do things that maybe seem, abnormal or even deviant. And that's okay. Without deviance from the norm, progress is not possible. And that is a quote from our friend here, Frank Zappa. And I think it really, the Zappa fans, all right, yeah. I said it was Frank Zappa because when I went and did a run through for this talk, somebody said, some of the people in the audience aren't gonna have any idea who that is. So you gotta make sure they know it's Frank Zappa. He's a musician, the guitar tells you that. But it is true that we need to be able to have that freedom to experiment without being afraid that we're gonna be punished for it. And that's what privacy is for. Now, this is the point where people usually say, okay, yeah, privacy, it sounds nice, but we have to catch criminals, and privacy gets in the way with that. That is a feature, not a bug. And you don't have to take it from me. You can take it from the Supreme Court. In 2018, the court decided a case which expanded Fourth Amendment privacy protections to a certain kind of cell phone location data. And in that opinion, Chief Justice John Roberts acknowledged this issue that we're talking about right now. And he wrote that a central aim of the framers was to place obstacles in the way of a too permeating police surveillance. And he acknowledged that this will, of course, make the prosecution of criminals more difficult. That may sound bad, but everyone in this room has committed a crime. And I feel confident saying that extra because we're in Las Vegas and it's the couple days before DEF CON, but I say this to other audiences as well because it's true. Whether it is drugs, trespassing, downloading music illegally, punching someone in the face. There's so many things that are criminal, and you all got away with it. Or maybe you all got away with it. The FBI estimates that 1 in 3 people in the United States has a criminal record. It makes you feel a little bit differently, doesn't it, about the person you're sitting next to? unless it's you who has the criminal record, in which case you're feeling pretty good right now. So let me describe the Fourth Amendment to you, tell you why it is weak, and then invite you in as experts to help, to basically help try to ameliorate this problem that we're talking about. So the Fourth Amendment is a prohibition against unreasonable searches and seizures. It says that warrants must be based on probable cause, and that they must particularly describe the place to be searched. So let me talk a little bit about particularity because it's maybe the oddest one. There's this really great example of particularity in The Avengers. There's the world is in this movie. And so in this example, they're trying to find the Tesseract, and Agent Phil Coulson brags that every camera that's wirelessly connected to the internet they're surveilling right now, even laptop cameras, as if Loki is using a laptop. And Dr. Banner immediately gets why this is wrong. And he says, he says, you have to narrow the field. Focus just on spectrometers tracking gamma rays. That's the way that the particularity requirement of the Fourth Amendment is supposed to work. Focus on the area where you're most likely to find the evidence. Don't just spy on everything. More hay doesn't make it easier to find the needle. So the Fourth Amendment looks pretty good right now, but it's filled with terms of art that make it less meaningful and less powerful than you might think. So first of all, it only applies to the government. It doesn't apply to private entities. Second, the definition of search is something where the government invades your reasonable expectation of privacy. And the law thinks that things are not private that pretty much everybody else thinks are private. And the particularity requirement, courts are just struggling and confused about how to apply that to modern technology. So the amendment hasn't really adapted to this new world. That was always true. It was always true that the Fourth Amendment had these weaknesses, but it didn't really matter that as much as it does today, because in the earlier times, our privacy wasn't really protected so much by constitutional law. It was protected by ephemerality. When we had conversations, they immediately disappeared into thin air. When we traveled through the world, there were no records of where we had gone or where we were going. No one knew if we were reading the New York Times or the Anarchist Cookbook. That's just not true anymore. The technologies I mentioned earlier keep track of our search histories, our web browsing, our cell phones and use of location services keep track of our locations. In the past, sometimes this data is kept for months or years or forever. And it's sitting there vulnerable to hackers, to identity thieves, to advertisers, and to governments, foreign governments, and to our own. So this is not a partisan concern. Republicans have complained about surveillance of Carter Page and extra financial scrutiny given to Tea Party groups and to MAGA advocates. Democrats have complained about spying on members of the House Intelligence Committees and journalists. No matter who's the person in office, this government power is an issue, and it should be relevant to everybody in this room, no matter what your political alliances are. So what does the Fourth Amendment have to say about all of this? That silence is the Fourth Amendment not saying anything because it's really confused. And it is allowing these bulk searches and confused for basically three main reasons, which I'm going to tell you about. data brokers, the repurposing of huge existing databases, and a technique called reverse searches. So first, let me talk about the data brokers. This is a multi-billion-dollar industry of companies that buy data, that create their own networks of surveillance cameras, that siphon information off of our cell phones with innocuous-looking apps that are actually shady and misleading. And then it bundles all that information together, and it sells it. And governments are some of its most lucrative clients. And the thing about data brokers is they're giving the government information that would be unavailable without a warrant, and just otherwise be unavailable without a warrant. And the thing that's important about warrants is that the reason why they're a check and a balance on government power is because a judge who's a neutral and independent entity reviews the law enforcement agent's explanation for why the information is needed and has to agree that there's a good reason for the search. And then the warrant itself describes with particularity what it is that the law enforcement agent is allowed to go get. With data brokers, there's no such safeguard. There's just a purchase, there's no review, there's no accountability, and not only is law enforcement able to get information that otherwise it would have needed to go through the safeguards of getting a warrant for, they can get this fire hose of information about us, which the particularity requirement would never have allowed. So it's just this huge data bonanza. In just one example, and I'm not going to give the names of any of these data broker companies because I'm not here to give free advertising to anybody, but in just one example, a company harvested location data from these apps on people's cell phones and associated that data with advertising IDs, and then they had hundreds of millions of phones information in the database, and then they sold this information to both the Trump and the Biden administrations to track people's movements en masse. Data brokers are also going to be really useful in tracking women seeking abortions. In 2025, there was a situation where Texas law enforcement collaborated with Illinois law enforcement to track the location of a woman who was traveling from Texas to Illinois to get an abortion, even though abortions were lawful in Illinois. Now, there may be some people in this room who are thinking to themselves, abortions are really bad, so whatever it is that stops them, I'm okay with that. I can get behind that. But remember, there are lots of laws where they're different in one state from another. And laws about gun ownership, gambling, cannabis. If you can be tracked across the border for something like getting an illegal abortion, you could also be tracked for these other things as well. You all are in a special position as security experts to take steps that might help keep consumers' and users' information safe. Can you make it harder to track individuals across disparate data sets? Can data be anonymized and aggregated in a way that makes it harder for data brokers to create these profiles of people? If you are somebody who sells data or gives government access to data, do you have Know Your Customer or other kind of safeguards in place to make sure that the information isn't being used for abusive purposes? I'm just a lawyer. I'm not an expert, but I'm asking you as experts to participate in this effort. The second topic, commandeering existing databases. We are in the middle of an unprecedented time where databases that were collected for one reason are being repurposed in service of President Trump's deportation policies. And this is information from the Labor Department, information about housing, information about health, labor, airline information, insurance, medical billing, all these different databases that government maintains that were collected for one mundane purpose are now being repurposed to be able to surveil millions of people for potential deportation. I'm just going to give one example, which is about the Internal Revenue Service, the IRS. IRS tax records are protected by statute, and I think most of us file taxes. The other ones who don't, maybe you're the potential criminals I was talking about from before. But this is some of our most private data. And normally what would happen is you would have to show to the IRS, if you're law enforcement, you have to show to the IRS that there's a reason you need this information before you can get it. But now there's this project underway to basically give immigration enforcement agencies just direct access to a database of information, estimated 7 million records that they're asking for in order to be able to track and find people. And the third thing I want to talk about is reverse searches. This is a technique that law enforcement uses all the time. In a location concept, it's not asking, was Jennifer at the scene of the crime? It's not even asking, where was Jennifer the night of the crime, a little broader, but it's asking, who was near the scene of the crime? And data brokers are involved in this technique as well, selling information so that law enforcement can conduct these ask these kinds of questions and identify people. If you think about this, even 10 years ago, but certainly at the time of the Fourth Amendment, if you told people, we're going to be able to go back in time and find out everyone who was near a particular place, whether it be a crime or a protest or whatever it is at some point in time in the past, they would have thought of that as witchcraft. Now it is an everyday occurrence in criminal courts. And so usually the company that's involved in these is Google, because Google has a huge amount of location data. The company has announced that it's in the process of storing this data in a different way so that these types of searches are no longer possible. And that's exactly the kind of thing that I'm hoping that experts like you who secure information will start to think about. How can we not have these enticing repositories of information? But we've seen warrants for these when Google demands a warrant, so that's good, good for Google. But sometimes we see these as pretty narrow warrants, but sometimes we see huge ones. Like, these are not easy to find because so much surveillance is secret, but we've found warrants that have been for like middle of the day 2 city blocks in San Francisco, an area that encompasses offices, hotels, restaurants, and this information is made available to law enforcement. We always focus on whether the right person got caught as a result of these, but what about everybody else who was in this area? What happened to their information? What's the risks to them? There's another example, which are reverse searches about your keywords, what you search in Google, and asking not just did Jennifer search for how to hide a body, but who searched for how to hide a body, even though there's many reasons why somebody might search for that. And in both these cases, courts have been super confused about what they should say the Fourth Amendment's role is. With the location data, there's one court that has said, this is a categorically illegal search, unconstitutional, because Google has to search through a database of 100 million people's location data. That is a general search that the Founding Fathers were against. You can't do it, not even with a warrant. Right next door, in the Fourth Circuit, the court has said, this isn't even your information. This information belongs to Google. You've disclosed it to them. You no longer have an expectation of privacy in it. And as we know, if there's no expectation of privacy, there's no search. And if there's no search, then the Fourth Amendment doesn't apply. Courts are in the same kind of confusion about these reverse keyword searches as well, trying to figure out, is this our information? And I think this is some of the most personal information we have out there, because it reveals our fears, what's going on in our mind, what we're most curious about? Or is this just Google's data? And since we've handed it over, we just don't have an expectation of privacy in it anymore. So let me ask, is anyone out here willing to share a week's worth of their Google search engine queries? Does anybody want to volunteer that? No, of course you don't, because this is some of the most private information we have out there, and yet courts are struggling with this, and so there's no certain Fourth Amendment protection for it, and that leaves us unprotected. Okay, so what I've talked about is 3 ways that I think are relevant to this audience that the Fourth Amendment is allowing bulk searches. And it's because the data is sitting out there, super enticing. So what I would ask is that we think about technological ways to protect some of this information, because we are really thinking here when we're talking about bulk surveillance, suspicionless surveillance, we're really thinking about the bystanders. And the bystanders are the ones who we don't know when our information has been acquired. We don't have any way of challenging it. We could have this information used against us at some point later on. We all know that tech companies and governments think it's good to just have the information sitting around, just in case for later. And we are sort of at the mercy of what could happen next. Our information is stored somewhere. Perhaps it's not stored securely. It can be misused in all kinds of ways. So one thing that I would encourage people to do is to notify. If you have a business and a government comes and gets your customers or your users' information, a lot of companies don't notify. The big companies do. Google does, Signal does, Facebook does. But often these demands come with gag orders or non-disclosure orders, and a lot of companies don't fight those orders. They just accept that they're not going to tell their customers, and then they never get around to it. Now, I'm a lawyer, so I know lawyers think these policy conversations are the lawyer issue or a policy issue and not a tech issue. But you guys are the ones who know what the information's impact is. You guys are the ones who know how it's stored, you know how sensitive it is, and you know how to protect and secure it. Try to be part of these policy conversations about how you can help protect the bystanders. Because, when we are watching action movies or thinking about, following the story, we're following our heroes. And at the end of the movie, when the Tesseract is secured and the Avengers have won, we're supposed to feel happy about what happened. Our heroes have made it through the crisis and have been successful. But we're not asked to think about the people who are in those car crashes we see, or who have had their bus drive off of the highway, or who have been smashed when the Godzilla monster crushes the buildings with his mighty tail. We're not thinking about the bystanders, and we need to. You need to, because you have the ability to secure and be stewards of our data. Here's what I recommend. If your company handles sensitive data, have a plan for how to deal if the government, ours or another one, knocks on the door and wants access. Have a policy to tell your users if their data is exfiltrated by law enforcement or some other entity. Let the users be able to take steps to protect themselves. Don't collect data that you don't need. It's common to do this just in case it becomes valuable, but here you want to be the Dr. Banner who's looking for the information that is going to be useful. You don't want to be the Phil Coulson who's watching me through my laptop camera. encrypt what you can, obviously, but overall include governments, not just criminals, hackers, identity thieves. Include the government and law enforcement in your risk assessment. In my world, the ACLU is trying to push the law to expand the Fourth Amendment to these new data types so that we can protect our communities, protect the public. It takes preciously forever. The government thinks that the Fourth Amendment only applies at the moment of collection. And then once the information is legitimately in the hands of law enforcement, they can do whatever they like with it for any reason whatsoever without ever having to have any oversight or accountability for it. My colleagues have been litigating a case for 11 years and have had groundbreaking success in getting a court to say that the Fourth Amendment protections apply not just at the time of acquisition of data, but when the data is searched later on. It's an amazing piece of legal advocacy, but it's one court, and it's been 11 years. Technology is much faster. Technology really took our privacy away, but I am optimistic that it can give our privacy back as well. And I am optimistic that people in this room who are experts in technology and in protecting information can be part of that effort, part of that success. So knowing what you do now, which is that the law provides precious little protection for our information, are there things that you could do differently? Are there ways that you can take into account criminals, but also governments as sometimes another threat vector that maybe initially when you walked into this room you didn't necessarily think of as a problem? You have the opportunity in your jobs and with your expertise to innovate, to think of ideas about how information can be protected, whether it's through anonymization and aggregation, whether it's through data retention. You can think about new ways to try to be part of the solution to this problem. And when you do that, you can go to bed at night knowing that you have created something, that you have implemented something that protects your customers, protects your users from suspicionless bulk surveillance. And you can be proud of yourselves that you offer a service that is safe and secure. So take into account all the threats that are out there. And you can also then be a superhero like the Avengers. So let's once again shout out to the Hulks out there, a shout out to my Black Widows who are here. And I hope that this is something that you'll think about. If you have other questions, want to talk about the Fourth Amendment, please do feel free to get in touch with me. There's lots of ways to do it here. And I just want to thank everybody for their time and attention today. And thanks for having me here on the Black Hat Keynote stage.